This is SSCG5. Demonstrate knowledge of the federal system of government as described in the U.S. Constitution. SSCG5a. There are four concepts of federal and state relations in the United States. The oldest and first was a concept of dual federalism. One easy way to explain this concept is through the metaphor of a layer cake. Each layer of government, state and federal, have distinct and separated areas of governance and powers with little shared. The second concept is that of cooperative federalism, which considers the state and the federal government as partners. Boundaries in this case between federal and state exercise of power are flexible, and the metaphor of a blended marble cake best exemplifies this concept. The third concept employs the Supremacy Clause as a guide and views state government as mere subsidiaries of the national government. Since the Civil War, failures of state governance led many to seek federal government action to fix states. For example, the Great Depression led to the national government to assert supremacy over the states in regulating the economy through the Commerce Clause. Similarly, the federal courts and Congress used their powers under the 14th and 15th Amendment to secure federally protected civil rights and civil liberties from state actions. The fourth concept, named New Federalism, views the move to national dominance and extensive regulation of the state's authority as overreaching. While not advocating a return to the strict separation of powers as called for in the dual federalism model, New Federalism seeks to return power and authority to the states in order to restore some authority and to permit innovations in government by the states. Chief Justice Melville Fuller explains the doctrine of the 10th Amendment and dual federalism succinctly in the E.C. Knight case. A federal monopoly case, Fuller explains that Congress's Sherman Antitrust Act can only apply to the interstate travel of goods and not the actual manufacturing of the refined sugar. That power to regulate a manufacturing monopoly is that of the state governments, and not that of the federal government under the Commerce Clause. As manufacturing plants do not cross state lines, the federal government lacks the power under the Constitution to consider regulation of these plants as being engaged in interstate commerce. Later decisions extended this rationale to mining and agriculture as well. Chief Justice Fuller summarizes Supreme Court precedent on previous Commerce Clause cases as well. Fuller claims the key issue is whether the regulated item physically crosses state lines. For this reason, Commerce Clause powers of Congress include trains, telegraph wires, radio signals, travelers, goods, etc. that cross state lines, and thus may be regulated by the national government. However, most areas of economic regulation would be placed at the state level instead of the national. Cooperative federalism presents a fuzzier concept. James Madison mentioned in Federalist 46 that the people of the U.S. will ultimately decide the boundaries of state and federal power. Which level of government is effective and responsive to people will cause people to support that level, gaining power and reducing the power of the other level accordingly. In practical terms, the concept of cooperative federalism has existed for a very long time. The existence of capable state governments at the framing, while the federal government was just getting started, led Congress from the very beginning to allow states latitude in exercising regulatory powers, which is often recognized through congressional legislation itself. The creation of federal navigation laws governing pilots' licenses for ships permitted state regulation of harbors and rivers as well. The cases of Gibbons v. Ogden and Cooley v. Board of Wardens ratified the idea that the federal and state government could both regulate commerce occurring through transportation. Only when the federal government decides explicitly to override state government regulations does the Supremacy Clause apply. Justice Curtis in Cooley v. Board of Wardens argues that past precedent of both Congress and the states for over 60 years established that the power to regulate commerce is not exclusively national unless the federal government establishes so by legislation. Furthermore, the nature of regulating commerce is more like the grant of taxing power to the national government, where state taxing power must be assumed to continue to exist. If states could not regulate commerce nor supply their own taxes, then they could not be considered sovereign under the Constitution and its 10th Amendment. In a later case, NLRB versus Jones and Laughlin Steel, the Supreme Court effectively abandoned the dual federalism concept for that of cooperative federalism regarding the Federal Commerce Clause. As transportation and communications became better, the U.S. economy became more national in orientation. Thus, Chief Justice Hughes tied Commerce Clause powers of Congress to the existence of a close and substantial relationship to interstate commerce. When properly exercised, this power trumps state power. Nevertheless, Chief Justice Hughes notes, when the effects on interstate commerce are negligible and remote, Congress cannot use the Commerce Clause to create a completely centralized national government. After NLRB versus Jones and Laughlin Steel, later Supreme Court decisions increased Congress's power and allowed a law to include self-sufficient farmer who grew and consumed trivial quantities of wheat to be regulated, despite not selling any wheat. This interpretation of the Commerce Clause was reiterated by the Supreme Court in Raich v. Gonzalez in 2005. The Supreme Court refused to allow a cancer survivor undergoing chemotherapy grow medicinal marijuana to combat nausea in her home for herself. Federal laws banning marijuana possession trumped California state law allowing medicinal use. In Gitlow versus New York, the U.S. Supreme Court began applying First Amendment protections to state actions, via incorporating parts of the Bill of Rights using the 14th Amendment's Due Process Clause. Protections of civil liberties from the states accelerated with footnote 4 in the 1938 Caroline Products case. The Supreme Court declared its primary purpose henceforth would be extending the protections of the U.S. Constitution to discrete and insular minorities. Chief Justice Earl Warren and the Warren Court exemplified national dominance over state actions. Starting with Brown v. Board of Education, the Supreme Court, along with Congress and presidents, extended national power to regulate state and local elections, demand states protect civil rights for minorities, and extend federal guarantees of the Bill of Rights to the accused. In 1985, a minor case involving the Fair Labor Standards Act's application to local government led Justice Blackmun, in his majority opinion, to claim the only limits on the federal government's power over the states, aside from enumeration, was the political process and set up under the Constitution itself. The court's majority brushed aside any 10th Amendment concerns over reserved powers and limits on the national government's power. The Garcia case in 1985 represented the high watermark of the concept of federal dominance. In the 1990s, the Supreme Court, for the first time since the 1930s, began to roll back federal powers using the 10th and later the 11th Amendments as grounds. The court primarily did this by narrowing the definition of commerce, which in turn narrowed federal Commerce Clause powers. This handwritten document is the court's decision in the 1819 case of McCullough v. Maryland, where Chief Justice Marshall explains the powers of the national and state governments. Enumerated powers are those mentioned explicitly in the Constitution and its amendments. Examples are the congressional powers to create an army and navy. Implied powers fall under two different categories. Inherent powers are needed by a branch to do its job, and implied powers are exemplified by the Necessary and Proper Clause in Article 1. For example, investigations by Congress represent an inherent power that helps guarantee the executive and judicial branches use congressionally delegated power appropriately. Similarly, executive privilege represents an inherent power of the executive to garner private and confidential advice from advisors necessary to make good executive decisions. Similarly, the judicial branch possesses inherent powers to create constitutional rules for itself, such as the exclusionary rule in order to render decisions. Implied powers come from the reasonable extension of enumerated powers, with each branch deciding how to implement their powers best. Using the necessary and proper clause as an example, Congress may choose the means by which it creates an Army and Navy. The power to create a separate military branch, such as the Air Force, is implied as a legitimate extension to congressional authority. The President's power to oversee the executive branch implies the power to require executive branch employees to follow presidential directives through an executive order. The court's power to adjudicate cases and controversies implies the power to determine in a case whether the party has suffered an injury in fact. If the party has not suffered an injury, then the court dismisses the case based on standing, as there is no controversy to be decided. Concurrent powers include the taxing power and the power to regulate commerce, which both the state and federal governments exercise. Unless the Constitution specifies that a power reserved for the federal or state government or banned from one or the other, then both levels of government may exercise these powers. One example is that states also have state constitutions that protect the rights of its inhabitants. However, no state constitution can violate the U.S. Constitution. However, states can offer more protection than the federal government does if it wishes. Reserved powers under the 10th Amendment include the police power to regulate for the health, safety, and welfare of state inhabitants, and include the exercise of any other government power not barred to it by state or federal constitutions. Because the states existed before the federal government, state sovereignty permits exercising powers not granted to the federal government. For example, the police power of the state permit adoption of state criminal laws that differ from federal law. SS CG5b. Because the Constitution was designed to secure the liberty of Americans and to prevent tyranny, state and national governments are prohibited from exercising certain powers. For example, neither state nor federal government may pass a bill of attainder, which is a trial and punishment by a legislative act. The federal government cannot punish states by splitting it, nor deprive it of equal representation in the Senate without a state's consent. Some enumerated powers, such as the power to tax under the original Constitution, were limited, so that the states could continue to finance themselves via taxes such as the property tax. The adoption of the Bill of Rights and the later 11th Amendment prevent the federal government from overreaching and depriving citizens and states of their rights and lawful powers. In order to prevent the state governments from usurping federal power as they did under the Articles, states are forbidden to exercise certain powers, which are reserved for the federal government, and some which require federal approval to exercise. SSCG5C. This diagram indicates the balance of power between federal and state governments in 1862. States and the federal government often engage in conflict over the control of policy. James Madison proved prescient in Federalist 10, where he argues that the compound nature of the republic prevents simultaneous capture of both federal and state governments by interest groups. However, this does spur conflicts. Immigration enforcement is an example, with some states wishing it to be stricter and other states wishing it to be more lenient than current federal policy. Both state and federal governments have the power to arrest and detain. However, the federal government has the enumerated powers of creating immigration laws. Congress has chosen to let the states enforce federal immigration laws under some circumstances, but still retains national power to dictate how. Other areas where state and federal governments differ are the use of law enforcement powers, taxing powers, drug laws, and transportation policies. SSCG5D. The Supremacy Clause was placed to prevent the collapse of national authority, which happened under the Articles of Confederation. As long as the federal government is exercising its enumerated powers, and those implied under it, then federal action is supreme over that of the states. Martin versus Hunter's lessee established that state laws that impinged on federal law could not be enforced. The later decision of McCulloch v. Maryland prevented the state of Maryland from taxing the federally chartered Bank of the United States, and Cooper v. Aaron declared the Supreme Court decisions enforcing desegregation were binding on state officials. CG5a. Amending the Constitution is a power reserved for the People's Branch, the legislative branches of state and federal government. Two methods allow Congress to propose amendments, with the states given the choice by Congress of either state legislative ratification or ratification through special state ratification conventions. A third method allows states to propose a new constitutional convention, bypassing the national government entirely with ratification by 3/4 of the states. This last method is the way that the current U.S. Constitution was adopted, but has never been used under it. Sources for this module. Sources for images in this model. Sources for images in this model, page 2. Sources for this images in this model, page 3. Additional resources for this module. This concludes this content module.